Hi, this is David Black. I'm a criminal defense lawyer in Phoenix, Arizona, and I'm going to be talking about a first offense DUI. So, a basic DUI, somebody who has never been arrested before, is, let's say, a professional, a lawyer, a young person, a student, and they get charged with DUI. Nothing special about it. So, there's no accident. It's not an extreme DUI. What are the things that the lawyer needs to know, or that I would want to know, in order to assess how serious the situation is? So DUI is complicated if you don't understand it, but it really boils down to two things that are very obvious: drinking, driving. So taken in a different order, let's start with driving. Can the state prove that you were driving? I want to know. I want to know if you were behind the wheel and an officer observed you commit a traffic violation. Because if he didn't, if it's an illegal stop, then I might be able to suppress the fact that you were driving, or the evidence that was taken thereafter entirely. That's not as common as we would hope as defense lawyers. They usually do their job. But maybe you weren't driving. Maybe you were sleeping in a parking lot. Maybe you pulled off the road because you weren't feeling great. Maybe you're struggling with housing and you're in college and you were drinking in your car. Well, Arizona does not officially have a bright line rule to say it's DUI if the keys are in the front of the car, it's not if they're in the trunk. Or it's DUI if the car's on, it's not if it's off. Arizona has a series of factors that have been developed through the case law designed to establish whether or not you posed an immediate threat of driving. And those factors include common sense things. Was the car on? Were the keys in the ignition? Was the car in drive? Were the lights on? And any other factors that law enforcement might reasonably believe led to them thinking that you were about to drive. And so, sort of on the one end of this spectrum, we have people who are pulling off the road. They've been off the road for 6 hours. The car is in park. The lights are off, and there is evidence that they're waiting for a ride in their phone that was provided to police. Well, that person is probably not in what we would call actual physical control. That person is not really posing an immediate threat of driving. What about somebody who, on the other end of the spectrum, falls asleep at a red light, car in drive, lights on, luckily foot on the brake? Police have to surround them, park in front, park in back, go knock, knock, knock. This is very common, by the way. Wake up the individual. They freak out. They might even press the gas a little bit. Okay, that person is almost certainly in actual physical control. So this is a jury question that we get to establish through evidence, and the state needs to prove beyond a reasonable doubt that, in fact, that person was about to drive. The next thing we want to know is, were they drunk? Now, drunk's not a legal term. So we're going to say, were they either above the limit of 0.08 or impaired to the slightest degree? So the limit in Arizona is 0.08, and it's not simply that there was a reading above a 0.08, it's that your actual blood alcohol at a certain point in time was above a 0.08. And there are margins of error, and they use scientific data, and we analyze that data with our experts to determine if they can really prove this. Can they get this evidence in, and can they prove it? Another way they can get that first regular DUI and prove that drunk element is by being impaired to the slightest degree. So all of those roadside tests that you see when you see somebody walking the line or finger to nose or holding one foot in the air, those are evidence not only collected to establish whether or not they should place somebody under arrest, but to then use at their trial to prove they were impaired to the slightest degree. A common question people ask: which tests should I do and which ones shouldn't I do? All right. No canned answer for this, but I can tell you a few things. In Arizona, you do not need to consent to field sobriety tests. You do not need to consent to the portable breath test. In Arizona, refusing those could be used against you to show what they call consciousness of guilt, which I personally think is silly because we don't really know what our own blood alcohol is. How could refusing show that I'm conscious of my guilt? But nevertheless, a jury could find out that you refuse those things. But typically, I would say, don't do those things. They're going to use those against you. Now, what about a chemical test back at the station, a blood test, a breath test, a urine test? Well, law enforcement has the right to request any or all of those tests. And if they have reasonable grounds to believe that you are under the influence and you refuse, then they take your license for 12 months. Gone. As a punishment for the refusal. That's called implied consent. I'm not going to tell you that the right thing to do would be to consent or refuse because it's so fact specific. But it's important that you understand that if there's anyone that you're required to do, it's the one back at the station. At the end of the day, if you can't get out of a first regular DUI, it is not life ending. We obviously do our best, and we have a good track record of minimizing the blowback, getting dismissals, getting reckless driving tickets, and reducing these things. But if you can't, you're essentially looking at a day in jail, about $1,500 in fines, some alcohol counseling, and license ramifications. That if you have questions about, feel free to call us. We're happy to talk to you about them. 480-280-8028.